Wonderful. Good morning, everyone.
Good
Welcome
morning.
today. Good morning. Welcome to an oral argument session of the Sixth District Court of Appeal. My name is Judge Nardella. Joining me today is Judge Wozniak and Judge White. I will be presiding. We have one case on our docket today, and it's Lee County versus Dean Wish LLC, 23-0879. Each side will be afforded 20 minutes to argue. Counsel for the appellant, would you like to reserve 5 minutes, or is there a different increment of time you would prefer?
5 minutes would be fine. Thank you.
We are being live streamed today on YouTube, so please keep that in mind. Counsel for appellant, whenever you're ready, you may proceed.
Thank you. May it please the court. My name is Chris Altenburn. I'm a member of Banker Lopez Gassler, and I'm here today representing Lee County in this appeal. This is an appeal of a final order denying attorney's fees to the county after it prevailed in a Burt Harris proceeding. The central issue in this appeal is whether Lee County is barred from recovering statutory attorney's fees in the circuit court proceeding because of the content of the order entered by the second district denying the county's motion for fees in the appellate proceeding in the prior appeal. The law of the case doctrine does not make an appellate ruling interpreting a fee statute like this binding on a subsequent trial court decision when the trial court decision involves different facts that affect the legal analysis.
It seems to me, are there two steps, counsel, that we have to agree with you on in order to agree with you on your entire case? Meaning, do we have to agree with you on the interpretation of the second DCA's fee order, and then also agree with you that law of the case did not apply?
In fairness to the second district, I didn't ask you to actually kind of like conflict with them, but yes, you do in fact have the authority in this case if you wish to disagree with an analysis of the second district, I believe.
Well, I think maybe it's more of a disagreement with the analysis of the trial court, the way that the trial court and maybe the appellee is interpreting the fee order from the second DCA. It seems like the parties disagree on the interpretation of the order and then also whether law of the case applies. Is that correct?
I think that's a fair statement. I mean, the language of this order says the second district was explaining that the order did not apply, or that it was denying fees because the situation was that that the statute was no longer applicable when the appeal was commenced and when we filed for a motion for appellate fees in the appellate proceeding. It never suggested that the order was not, or the statute was not applicable when the case was pending in the trial court. You know, if anything, its use of the word when in the order and its comparison citation to Diamond Aircraft supports the county's position that it was entitled to fees in the trial court until that transfer occurred. The second district probably took the extra time to write this short order explaining the limited scope of its ruling, not to tie the hands of the trial court, but to explain the limitation on to fees for only the purposes of that appeal. And that's how I interpret it. I think that's what the second district intended it to say. Obviously, I think my opponent disagrees with that analysis of what it says. Dean Wish raised the affirmative defense of law of the case for the first time at the hearing on entitlement. If that defense doesn't apply, the county really is entitled to fees under the statute. The Burt Harris Act waives the government entity's sovereign immunity and provides property owners with rights far in excess of those required by the Constitution. But the exercise of those statutory rights comes with a risk of paying fees to the government if the government prevails in the lawsuit.
And counsel, who bears that risk of paying the fees to the government?
The risk of paying those fees is brought by the person who files the lawsuit.
But doesn't the statute use the definition or the term property owner?
It does repeatedly use the word property owner, but in the sentence when it gives the government the right to fees, it doesn't say that you receive rights from a property owner who remains the property owner. The property owner, and Dean Wish was that at the filing of the lawsuit, made the decision to file it. It claimed it was entitled to benefits of this statute throughout the trial court proceeding. And when it did not prevail, that statute doesn't say that by disposing of the property, they could somehow evade the fact that they needed to pay the fees if the government won the lawsuit. And the government prevailed in the lawsuit after it had made a proposal to settle this before the lawsuit, when Dean Wish was the owner, and after Dean Wish had rejected that offer as the owner, and when Dean Wish had filed this lawsuit as the owner. So nothing on the face of this statute says that it is conditioned on someone not transferring the property to someone else during the lawsuit.
I noticed that in the subpart before that, when it talks about the property owner being entitled to costs and fees, it specifically says that the fees would come from the governmental entity or entities, but I don't see something similar language-wise in the subpart under it, which is the one that we're dealing with. It just, to me, it's saying the governmental entity is entitled to recover costs and fees, but it doesn't specifically say from whom right after that. Does that make a difference?
That's correct. The language of entitlement for fees isn't the standard. Either party who prevails wins. It's got a standard that explains what a prevailing party is for a property owner, and another one for what the government entity is. And the one for the government entity, I mean, traditionally you get fees in a lawsuit if you win as the defendant from the party who sued you. And it doesn't make any difference what their actual status is as a property owner or a citizen or someone registered to vote. If the one they filed the lawsuit against you, that's the one you get the fees from. And so the statute doesn't say anything different than what a normal statute would say here. Now, Dean Wish claims that somehow this is different because the right to fees is conditioned by more than prevailing. But as addressed in the briefing, conditions that are often attached to a statute to explain what it means to prevail for fees for purposes of various statutes, whether it's frivolous fees or the like. And those things do not change the analysis of whether law of the case applies here. So if I can
But
turn
counsel, if going to the provision subsection 6C, and then there's 1 and then there's 2.
correct.
So 2 is the one that your client is claiming fees under. And so to get fees, your client has to prevail in the action, which is undisputed, is my understanding.
Yes.
And so conjunctive, the court determines that the property owner did not accept a bona fide settlement offer.
That's correct.
Okay. So if I understood your statement earlier, we don't have to follow the second DCA's construction of what the statutory term means. But if we follow what they decided in their opinion, the property owner means, which is present tense, would you agree that for your client to get fees at the time that the court makes the determination, it would be the property owner present tense that would be inserted into that statute, the name of the entity, which would not be the appellee, right?
No. If you read the decision by Judge LaRose in the second district, he's measuring a different part of the statute that talks about that the property owner is the one who is entitled to the remedy. And that's a different part of the statute. And because this is a waiver of sovereign immunity, has to be strictly construed, he concluded they had to be the owner at the time that they were entitled to the remedy. And that by selling the property before trial, they abandoned their right to have the remedy at trial to get that result. Now, when you look at 6C2, the language there and the tenses used throughout the statute vary. And there's nothing in section 6C2 that says that in order to recover these fees, that the property owner who commenced this has to remain the property owner to the very end. I mean, again, if they could just pretend never mind, I was never the property owner, because today, 4 years down the road, I'm not the property owner. It would really kind of eviscerate the intention of the legislature and giving them additional rights beyond the Constitution, but conditioning those on, if you lose, you're going to pay fees. So I think there's a distinct reason why the language in the remedy portion of this and the language in the fee section of this are different from that.
But the term the property owner, as construed by the second DCA, is present tense, right?
Yes, and the word property owner is not in the sentence that gives me fees, not for purposes of who I get the fees from. It's only conditioned in the past tense that I made an offer to a property owner and that the property owner rejected it and that the property owner filed the lawsuit. All those things in the past tense, Dean Wish did as property owner. It's only when we get to the end and it looks like they're going to lose that suddenly they're no longer the property owner in this case. And nothing in the statute on fees changes that analysis.
You're on mute, Judge Nardella.
Thank you. Counsel, can you speak to us about the method for determining the period of entitlement? You do so somewhat in your brief, but I was hoping we could get more detail about it today. As I see it, there's three possibilities. One, it's the period should be the entirety of the case. You triggered it. Second DCA appears to reject that in their order, but setting that aside, that's one option for determining the period of entitlement. The second, which I read the appellee as forwarding, is the fact that you never get it. If the act never applies, you never get fees, even if you litigated under the act while there was questions of its applicability. You still don't get fees for that. And the third is the split, which you see the Florida Supreme Court adopt in Diamond. Is there another avenue that we're missing that determines the period of entitlement? And which do you say? I know you say that Diamond is practical and logical, and we should you think that's the road that we should go, but is there, so my question is two-part. One, is there a road that I'm missing? And two, what would you advocate for in addition to, if anything, aside from Diamond?
I think Diamond applies in the context of most statutes for attorney's fees. Diamond was a case, of course, involving issues on trial court fees. And if you first, this statute, I don't get fees for all the work we did when we were trying to resolve this before trial. The statute itself sets the start date. And what Diamond Aircraft resolved was when that period might end. Now, Second District in this case and in Mack took a little bit of a different approach to this, but the bottom line is that under Diamond, if you're the plaintiff and you say the statute applies, then if there's a prevailing party statute, you have to pay fees so long as it remains unclear as to whether the statute applies. Frankly, Diamond Wish continued to argue this down the road, but the Second District used the language of Dean Witter, of Diamond Aircraft, to say that it's going to be cut off at the point where the statute no longer applied as a matter of law because they disposed of the property. And we didn't contest that before, and I think, frankly, that's a fairly sensible approach to doing this. We could have argued more about whether they were owed fees because they were arguing application during the Second District's appeal, but that's water over the dam. So I think logically the cutoff made by the Second is applicable, even though it's precisely the same statute. So I'm down to 6 minutes. I want to emphasize
Question that I just want to make sure that I ask both sides. If we were to write an opinion on this, I want to make sure we get it right. What year of this statute is applicable to this fees proceeding in the trial court? I think 2019 in your brief, counsel. I'm not sure if I saw a year in the appellee's brief.
It doesn't make a whole lot of difference other than that there was an amendment, to clarify this after the Second District's decision. But I would think that the fee statute that would control if there is a difference would be the one at the inception of the lawsuit when they made the decision to file it, when we made the offer and when they decided to file. They actually filed this lawsuit in January of 2017. The offers were made in the fall of 2016. So the statutes that kicked in June of 2016, I would think to be the applicable statutes.
Okay, thank you.
You know, the only thing I want to emphasize on all the cases, my time being short, is that, you know, U.S. Concrete said that the doctrine was restricted to questions actually presented and considered in a former appeal. And then Giuliano said that it includes issues implicitly addressed or necessarily considered by the appellate court. But it also emphasized that it was not that the trial court would not be bound by decisions that were not before the appellate court for adjudication. Dean Wish admits that the issues of trial court fees were not actually presented to the trial court. That issue had not even been considered by that court in the trial court, and the second district wouldn't have jurisdiction over entitlement in any event, even if that had occurred. Because of that, Dean Wish, in its answer brief, has tried to quietly claim that it tried to finagle an order out of the second district that would have discussed the issue of trial court fees. And it did this by language that it put into its response to the county's motion for appellate fees. But it didn't obtain that language in the opinion or in the order. The second district actually had its own separate analysis that it created itself. So this gotcha approach to the case really does not help them here. They argue that we should have moved for rehearing, but we only asked for appellate fees, and the order appeared to resolve that. If Mac had been out a couple of weeks earlier, we might have moved for rehearing, but not because we were concerned about appellate fees. So if there's anyone who needed to move for appellate fees from this one sentence order to clarify, it was Dean Wish. It was Dean Wish that had a quiet plan to raise this as law of the case on remand. And it didn't obtain a discussion from the second district that it claims it wanted. And as a result, if they actually needed a clear legal decision from the second district so we could claim the second district that decided this, they're the ones that needed to move for rehearing, and they didn't. It's a practical matter. I don't think the second district would have granted that motion or done any further explanation, but they're the ones who needed to do that. So this case, this court should reverse the order on appeal and remand for further proceedings at which the county can prove that it had made a bona fide offer prior to Dean Wish's decision to file the lawsuit back in 2017. So unless there's any additional questions, I'll save my 3 minutes for rebuttal. Thank you.
Counselor for FLE, whenever you're ready.
Thank you, Your Honor. My name is Hala Sandridge, and I represent Dean Wish. So the county claims that Diamond addresses the period of entitlement for trial court fees and that this court should provide guidance to the trial court on remand. This is really a new argument. For the last 2 years, the county has been arguing that the second DCA fee order did not decide trial court fees, only appellate fees. Yet now the county claims the second DCA reference to Diamond was to indicate the method for determining the period of entitlement for trial court fees.
But counsel, isn't their argument a little more nuanced? Aren't they just simply saying that the citation to Diamond as a compare is suggesting that at least it's clear as day, by the time this was appealed, the act didn't apply? Isn't that different?
So no, I do not think so. I think that the reference, what the court was acknowledging by the CF is that a party's standing on a statute can affect a fee claim, and it can. But because the portion of Diamond that the second DCA cited addressed amount, not entitlement, it was nothing more than a CF. That's all that the second DCA was doing. This new argument about period of entitlement is exactly that. It appeared for the first time in the reply brief after having argued both in the trial court and in their initial brief that the purpose of Diamond was to decide the issue. And so what we're here to tell you is that this recently concocted period of entitlement argument is just a different way of saying what we've always argued, which the reference in Diamond is simply to amount, not to entitlement. And so where the briefing kind of leaves us right now is that the only issue before the court is whether the trial court was bound by the law of the case as created by the fee order. And
Counsel,
yes,
I'm sorry. And I've never had the pleasure of having such extensive briefing on the use of the CF signal as I had in this appeal. But what do you think the C signal means? And the
compare.
citation to the statute, no, not the CF, but before that, the second DCA in its order
Oh, the
used
C.
the C signal to the statute and then a parenthetical. What do you think they were trying to tell us there?
Oh, I think they gave us the answer to the question. And that's where I was headed, Your Honor, is they were telling us that the same application that they decided on the merits applied to the determination of the statutory fee language, which was not limited to appellate fees or trial fees. It's the same language applied to an application of fees, whether it's sought in an appeal or in the trial court. And I want to make this very clear. We brought this very point up to the appellate court, to the second DCA, in both our briefing and in our fee motion, and we did not limit it to appellate court fees. We argued that if the court accepted the present tense construction, as they did, then it affected every instance of the court's analysis of the statute. And in fact, if you take a look at the court's order, it says exactly that. So if you take a look at the opinion from the second DCA, I'm citing at page 847, it says, in fact, the Act continues to use the term property owner to outline the trial court's procedures to determine compensation and fees. This, and remember, this is after we argued this issue in our briefs, and we argued it in our fee motion. Put simply, the Act's plain language requires a claimant to be the current legal title holder of the impacted property to obtain the available remedies. And they've just described the remedies as compensation and fees. And then they go through the same analysis that they adopted about inserting the pertinent definition of the definition into subsection 2, and they say, however, the continued use of property owner that is defined with the present tense communicates that the property owner must continue to hold legal title to the property owner at all stages of the litigation. All stages of the litigation. And we use the language in every instance in our motion, but I submit to you that all stages of the litigation is no different than every instance. And so it is clear to us that the second DCA, when it used the language, Judge White, that you referred to, was referencing back to this argument that in all instances, we needed to be the property owner for the Act to apply. And that is exactly what that language is referencing back to. Here's
on to appellant counsel's argument that here on this appeal, we're talking about a different, there was the reference that you mentioned in the second DCA opinion to subsection 6, but that really wasn't before the second DCA squarely at that point. It was whether your client was entitled to relief. And then they also referred to subsection, I believe it's 2. Yes, that's what appellant's counsel was referring to. And it talks about the property owner is entitled to relief, present tense, as opposed to in subsection 6, if I'm understanding his argument, it talks about the property owner did not accept, past tense, the modified offer. And so what would be your response to that construing both the property owner, but then also the use of the is in the one subsection did not in the other, that could support a different result when it comes to the attorney's fees for the government here, even though your client was not entitled to relief under subsection 2?
So I think that the answer to that question is, again, the second DCA opinion, right? Which says we're going to take the definition of property owner and insert it in everywhere that property owner is used. And what's good for the goose is good for the gander. I mean, we disagreed with that construction, but if the definition of property owner is inserted in here and the property owner holds legal title, we're not the property owner holding legal title at the time. And you notice this, Judge White, that in subsection 2, it says when the court determines that the property owner, so at the time the court determines this issue of whether the property owner did not accept a bona fide settlement offer, there was no property owner. It was gone. There was no property owner holding legal title to this other than somebody who was not a party to this lawsuit. And so it is very clear that if you use what the second DCA said you use, which I believe is law of the case, and let me turn to that for a moment. I understand that this court can disagree with the construction that was put on this by the second DCA. Obviously, we do too. But law of the case, judicial estoppel, manifest injustice, pick your doctrine. The same rules should be applied clearly throughout this case. And so all we're saying is that if you take that definition and you put it in as the second DCA said you do, and we have to be the property owner present tense for all instances under this lawsuit, then I think our construction is the correct one. Turning back to another point that I think is really important here is that the second DCA really rejected the argument that the county is now making, because here's what they say. The test, and this is on page 12 of their reply brief, the test of the statute plainly requires that these events must occur before the lawsuit is filed. The property owner who did not accept a bona fide settlement offer must be the property owner at a time prior to the lawsuit. If that is correct, the second DCA rejected that argument, because if that were the case, then the county would have received appellate fees, but it didn't. So the second DCA rejected the argument that the county is making now. The other point that I think is really important here is that our position on fees is based on the same argument on which the county won its merits argument. We're not taking different positions. The only one that's taking a different position here is the county. And so from a consistency standpoint, again, we weren't happy with the outcome of the decision in the second DCA, but applying the same language and analysis to this statute, we prevail on the fee issue. I'd also like to go to what they have said about a one sentence order not being law of the case. A PCA creates law of the case. And that's because the law of the case is premised on what the parties raised and argued in the appeal. And here we raised and argued this very issue. We said that if you accept the court's construction, the county's construction, then for every instance, and we specifically mentioned attorney's fees, not appellate attorney's fees, but the attorney's fees under the statute, then we were not the property owner for purposes of assessing attorney's fees. And I'd refer you to Langer versus Fells, where a party claimed entitlement to trial fees, and then they argued that the appellate order denying fees, and that's all it was. It was just an order denying fees. They said that it did not create law of the case, even though it was the same statutory provision. And the fourth DCA rejected that argument. And it said that the absence of an explanation for the denial did not eliminate the law of the case doctrine. They looked to the issues raised. And so I would ask this court to go back and look at our opposition to attorney's fees. Look at their argument in their answer brief, page 23, filed on 5/22/2020, in which they say, as further proof that the claimant cannot divest itself from the title to the property, the legislator further provided that only a property owner is entitled to receive fees and costs. That was their position they took. We responded to that in our reply brief and said, look, if you're going to accept that position, then you don't get attorney's fees in this case. And again, it wasn't argued in terms of trial fees or appellate fees. And here's why. They are confusing issue and claim preclusion. What we are saying is that the second DCA decided a statutory construction issue and it applies throughout. We're not saying that they decided the issue of trial court attorney's fees, but they decided how to construe the statute, and that same analysis applies here. It's issue preclusion, not claim preclusion. Judge Wozniak, you had asked about the fact that in one section, they refer to fees against the governmental entity, and in the second, not against the property owner. I would submit to this court, who else are the fees to be assessed against but the property owner, the person who brought the lawsuit? I think it would be an absurd construction, and the Supreme Court has told us we need to look at context, and the context of this statute is clear that the only person who could ever be responsible for attorney's fees is the party that initiated this lawsuit, the property owner, and we were no longer the property owner.
Counsel, if we disagree with your reading of the order, and if we disagree with your law of the case argument, why shouldn't we go further and at least explain to the trial court judge the correct method for determining entitlement, the period of entitlement?
So the issue of period of entitlement goes to amount and not to entitlement.
But aren't they hand in hand? I mean, the question of it's entitlement for what period? It's not simply a question of amount.
Sure. So let me go through what typically happens. And I can tell you what happened in the Diamond case, because that was my case in the Supreme Court.
No, I understand that.
And so what we were arguing there is that we were, the issues were intertwined. And Judge Nardella, I know you were a trial court judge. You probably had to handle fee issues. And so the parties come in and they first determine this legal issue of entitlement. Is there a statute? Is there a contract? There is no second step for determining period of entitlement. Period just means, what time did you spend on this case? And that's exactly what the Diamond Court was looking at. They were looking to see whether Diamond should receive fees for work that it did that was so intertwined after it won the summary judgment. That was the pitch I was making to the Supreme Court, and they rejected it. And if you look at their opinion, they make it very clear that they are focused on cost and time and hours and not entitlement. So there is no issue for period of entitlement. The first issue, the only issue, is whether or not there is entitlement. Now, I think everybody has agreed, Your Honor, that if entitlement existed, and we don't think it does, that they could only get fees through the time period of the summary judgment. I think everybody's in agreement on that. And I think that's consistent with the Supreme Court's decision in the Diamond case, which is at that point in time, your work kind of stopped because you were no longer defending this FDUCTA claim. And so the time period for which you can get fees is only this. I think everybody here has agreed that they cannot get fees past the time of the summary judgment because we were no longer the property owner. And I think that's a standing issue. So I think what this court has to first decide is the issue of entitlement. And it's our position that you can decide this even if you disagree with the trial court's ruling, because it's a pure legal issue. And the legal issue that is before this court is the statutory language of whether or not, number one, I think everybody agrees on prevailing party. And as Judge White said, and when the court determines whether the property owner did not accept a bona fide settlement offer, is factually correct, and no dispute about this, that when the court made that determination, when they filed their motion to determine entitlement under Rule 1.525, that's the only thing that triggered entitlement. At that point in time, we were not the property owner. And so the court could not determine that we, the property owner, did not accept a bona fide settlement offer. So if this court agrees with us on that construction, then that ends the issue. Then they are not entitled to attorney's fees. And I think that this court could find that regardless of whether it agrees with exactly law of the case or how the trial court resolved the issue.
I want to make sure I ask you about the year of the statute. Do you agree that it's the 2016 version of the statute that's applicable here?
I would say it's either the 2016 or the time that they filed their motion for entitlement. And neither of those dates have any differing language on these issues.
Thank you.
I want to make one final point that I think is really important here. It's this idea of some sort of gotcha tactic. Dean Wish was out in the open about his argument. It expressly argued that if the second DCA accepted the county's construction in the merits appeal, then that construction applied in every instance that the term property owner is used. But the county had to make a strategic decision about this statutory construction argument that it heard. And if it won, the county saved millions of dollars on the takings claim, but it lost the county's claim for attorney's fees, which was obviously a lower amount. And it appears it made the right decision. Certainly the right decision for the county's taxpayers, but Dean Wish was also the beneficiary of that strategic decision. And we were really out in the open about that. To say that we did not explain that in our motion for attorney's fees or in the appellate pleadings is wrong. So the second DCA was aware of our decision. The second DCA made clear in its decision that the attorney's fees issue was included in its analysis of the present tense. And I will tell you that under these circumstances, the county's claim of unfairness, gotcha tactics, or clever outlawing really rings hollow. These were strategic decisions that everybody made, and I don't believe that they deserve the title of gotcha tactics. If this court has no further questions, I would rely on our briefs for anything that I have omitted from my argument today.
Thank you, counsel. Counsel for appellant?
Yes, let me quickly answer about 3 or 4 things here. Let me start with entitlement to fees in the trial court, by the way. They make this argument that our entitlement was based on Rule 1.525. Rule 5.1525 is a motion you file to seek a judgment on fees after you prevail. But it's very clear under the case law that it's the pleading for fees that you do in your answer that creates the entitlement. And we raised and demanded fees in our answer, Record 408, and numerous other times. So this notion that somehow that motion is jurisdictional or substantive the way it is in appellate courts doesn't really make much sense. In answer to Judge White's questions about, the C as SEE site in the order, it sees the statute and then it quotes the statute, and the statute says, in any action filed pursuant to this section, the government entity or entities are entitled to recover a reasonable cost and attorney's fees if the governmental entity or entities prevail in the action and the court determines that the property owner did not accept a bona fide settlement offer in the past tense. I don't know exactly what they thought that answered, but they went immediately then to Diamond Aircraft to say, we conclude that Diamond Aircraft is entitled to fees, but only for the period of litigation until the federal court held that FDUPTA did not apply. So they were backing up to explain that the cutoff of that statute was when the act no longer applied, and that the act no longer applied when the judgment was rendered and the appeal was filed, and they looked at a motion that we filed on appeal. So I don't think that you can isolate these two things together. That the time period in Diamond was used for them as the justification as to why they didn't have to file fees. Now, whether they thought they were ruling more on trial court, it's not very clear to me on that. I would point out, by the way, they've cited to briefing they chose to supplement the record only with their response on attorney's fees. This was in the second district. You could just go look at the record in the last appeal. And I don't think it's actually in front of you what the briefing is. I don't really care whether you look at our briefs. I'd be happy to supplement your record with the briefing that was filed in the second district if you don't have it. But I don't think that briefing is going to support them on that. Finally, I'm down to 8 seconds, so I think I'm running out of time. And so I'll stop there unless there are additional questions. Thank you.
You're on mute, Judge Nardella. Still on mute. There you are.
Awesome. Sorry about that, guys. Thank you for your arguments here today. We will be adjourned.
Okay,
Thank you.